and you proceeded to curse at her multiple times, repeatedly saying that the quote, the officer had written this stupid, paraphrasing, effing, back to quote,
This isn't just
ticket.
about glasses. It's a clash of attitude versus authority, facts versus feelings, accusations of rudeness, talk of police quotas, and a judge who's not holding back. Stay tuned. This is about to show how quickly a small ticket can explode in court.
Jared Regier for the state. The defendant, Ashley Miller, appears in person and proceeds.
Violation of license restrictions may sound minor, but it's serious. $200 fine, 30-day suspension, and no diversion because of prior offenses. The judge is making clear, past behavior closes doors. This isn't a warning. It's already stacked against her.
Fine of up to $200. A 30-day driver's license suspension is mandatory. You do have the right to plead not guilty and set this for trial.
Repeatedly calling the case stupid in court is risky. Judges weigh respect heavily, and tone can hurt more than facts. Even if you think the charge is unfair, every dismissive word builds the image of a non-cooperative defendant, and that image matters.
Today, depending on your history, if any, you're not going to be eligible, I don't think, for diversion. I was going to say you might be eligible for diversion, but it looks like you may have had a diversion for
a while ago.
Well, yeah, 23 for expired tag and 19 for speeding. You were found guilty. So I don't think diversion is going to be an option for you. But again, I don't decide that. While you're pondering those things, though, Miss Miller, I want to comment that on April 15th of 2025, you called in to the clerk's office. You'd called in previously. And on that date, you spoke to one of the most friendly, considerate clerks. We have a lot of them, but the one you spoke to is exceptionally good at helping people. And you proceeded to curse at her multiple times, repeatedly saying that the quote, the officer had written this stupid, paraphrasing, effing, back to quote, ticket, just so he could make money from you and make a stupid quota, end quote. You repeatedly asked what your costs were. The clerk informed you that there would be court costs most likely added to your case, depending on what you were cited for, but without seeing the ticket, she could not inform you of the other fines and fees. You told her that this was stupid. It was stupid that it had gotten here in the first place. You told her you were cited for something stupid because you've never worn your glasses and you didn't know why it was ever marked on your license anyway.
The judge links clerk disrespect to disrespecting the entire court. Legally, court staff are extensions of judicial authority. Whether you liked the clerk's attitude doesn't matter here. It's your obligation to maintain civility in any court interaction. Optics over emotions.
On the date and time indicated. You again said it was completely stupid that you had to appear for court and that you couldn't believe you had to pay court costs and everything, even though you thought this case was dismissed or should be dismissed. The clerk went on to try to tell you that if it was dismissed, you may not have to pay any fines or fees. And then you hung up on the clerk before she was able to get a response.
I'm not sure as to what this has to do with the clerk, considering we're in court right now. So I'm confused.
It has everything to do with the clerk because A, it has It has a lack of respect for the court. It is the clerk of the district.
The judge links clerk disrespect to disrespecting the entire court. When a judge questions your tone, it's a warning shot. Courtroom perception goes beyond words. Demeanor, pacing, and delivery all count. Self-represented defendants have no buffer, so one slip can shape the judge's entire view before evidence is even discussed.
What you encountered is, to the best of my knowledge and belief, extremely courteous, patient, and polite.
And generally, when I had called, I was trying to be patient, courteous, and polite, and treat her with kindness and respect. But she was extremely short with me. Also, I'm autistic. This is about facts, and I don't understand why we also have to bring feelings into it. It's inappropriate for me to bring feelings into it, so that's wrong of me, and I own that. But also, I don't want them bringing their feelings into it either. This is about facts. I'm trying to get the factual information so I can do what's needed of me to be a law-abiding citizen. So
this has nothing to do with feelings. This has to do with respect, which is a sign or symbol that you appreciate the role of the court, that you respect the law, and so far you've not shown that. And that doesn't help you get very far.
Driving without prescribed glasses is framed as a safety risk. Courts prioritize public safety over personal judgment, even if your eyesight feels fine. The state relies on standardized testing, not self-assessment, to decide license restrictions. That argument hits hard in trial, said.
I never said that. You said that.
Yes, I did, because that's what I conclude, that you're being rude.
I'm not trying to be rude at all.
All right. Well, you are being rude. Now, Miss Miller, whether you think this charge is stupid, whether you think you need eyeglasses, apparently someone tested you at some point in time and said you do. And that if you don't wear your eyeglasses when you're driving, that could be a risk to other motorists and pedestrians, or even to you.
Opting for a bench trial means the judge decides the verdict. No jury, no emotional sway, just law and facts. With an already skeptical judge, this strategy only works if the restriction was clearly issued in error.
And I passed
Otherwise,
the
odds
eye
aren't
test.
great.
I guess I'm unsure. I didn't realize it would even get this far where we are going to have to go to trial over somebody marking it was wrong on it shouldn't have been marked because I passed every vision test. So I don't understand. I'm extremely confused so I guess we're going to have to go to trial.
All right.
Quota accusations make headlines but rarely win cases. Even if officers have targets, it usually doesn't void a valid stop. Still, the judge allows her to raise it in cross-exam, a slim chance to shift the focus from safety to motivation.
Your Honor.
Yes?
I apologize. It'll actually be September 17th. August 27th is full.
Thank you. We will set this for bench trial September 17th.
No court-appointed attorney here. Max sentence is 30 days. She must hire counsel or go solo. Self-representation can feel empowering, but one misstep in questioning, procedure, or tone could easily tip the case toward conviction.
I don't have to post a bond. Anything else, Mr. Regier?
No, Your Honor.
All right. Anything else, Miss Miller? You do have the right to hire an attorney, but because the maximum sentence is 30 days and not 6 months or more,
This hearing is only the prelude. The trial will decide it all. But today's tone warnings, safety framing, and quota talk will echo in September. First impressions in court are powerful and hard to erase.
All right. Then you're excused at this time, Miss Miller. Thank you.
Next one I have is Jamie Cantu. Cantu, starting with a C.
Thank you.
Next stop, September bench trial. Stakes, suspension, fine, and a legal record. Lesson, respect the process, even if you disagree. If this case grabbed you, hit like, drop your take in the comments, and subscribe for more courtroom breakdowns.